You're listening to Chicago Stories, a podcast from City Hall featuring the stories of everyday Chicagoans and special guests, as told to Mayor Rahm Emanuel.
This is Mayor Rahm Emanuel. We're here on Chicago Stories. We're joined by Gerald Rosenberg, a professor of political science and law at the University of Chicago. His new book, The Hollow Hope: Can Courts Bring About Social Change? Can I ask you, how did you get interested in this subject?
I grew up in the 1960s.
That explains a lot.
I think it does, but part certainly of the anti-war movement, the civil rights movement, then the women's movement, the environmental movement. I grew up in New York City, too, so very dedicated to not only helping to make social change, but understanding it. Then I started law school. And I realized by day 2 or 3 of law school that law school was really the legal side of business school. And I wasn't
Law school is the legal side of business
school. In other words, law school's mission is to train corporate lawyers, lawyers who represent business. I wasn't interested in that. So I left after my first year of law school and went to England for 2 years to do a master's degree
in
politics and had a wonderful time. But in England, of course, the courts do not, or did not at that time, have the power to invalidate acts of the parliament. And so I would explain how important courts were in America, and the English would look at me a little askance, say, that can't be right. And that got me thinking, and that's what got me into it. I wanted to know what was the best strategy to bring about social change, and more narrowly, whether litigation was an effective strategy.
Now, do you think the courts are an agent of social change or a prohibitor of social change, given that's what you study?
I wish I could give you a simple answer. It is complicated. Courts can do many things very well. They can protect individual rights. They can put unsafe products out of business. What courts are less good at doing is bringing about nationwide change. So you think of famous cases, Brown versus Board of Education, which said race-based segregation in public schools was unconstitutional. Didn't make that much difference empirically. So my work tries to study what actually happens to people's lives after court decisions.
That's one way to evaluate it, right?
Correct.
I mean, the other way to say is Brown v. versus the Board of Ed actually was the key in the ignition for a lot of civil rights change, not education in a sense of discrimination.
And I took
Without it, I mean, voting rights may have happened, but it may have taken it longer.
Or the 64 Civil Rights Act might not have happened. I always believed that. So I said, let me look for the evidence that will show this. And indeed, my initial argument was courts might not bring about direct change. In other words, after Brown, we might not get immediate school desegregation, but there were all these indirect effects. Perhaps Brown inspired the civil rights movement, changed public opinion, pressured Congress to act. And I started looking for evidence to support these claims. And I couldn't find it. And I kept looking harder and harder, and I couldn't find it. And then literally one morning I woke up and said, the problem is not that I'm looking in the wrong places. The problem is the court did not have these effects. And then the book wrote.
A couple things. One, in history, while a lot of people historians describe Roosevelt's attempt to stack the court, given its resistance to the New Deal, as a loss, you describe it as an incredible win.
That's correct.
Why?
Because what Roosevelt wanted was to get the court to end its prohibitions on using federal government power to deal with the Great Depression. And the court started to do that. He introduced his plan in early February of 1937, and starting in March, the court began upholding not only federal government intervention, but state government reversing 50 years of its doctrine.
So even though it was a temporary setback, you think in the end of the day, it carried the day?
There's no doubt that he carried the day. And that's what led to, by the way, upholding the National Labor Relations Act, which we still have today, Social Security, which we still have today, unemployment insurance. Those were all laws that the court upheld starting in the spring of 1937.
It's interesting. It may have been that he got the New Deal, but I think they describe it as lost because some people think his political hold starts to get cracked. I mean, he was invincible from 32 till that, is it 38?
37.
37.
Yeah, no.
I knew that. I was just testing you, Professor.
Yeah, of course.
Yeah.
Look, certainly the data support that.
Right.
He was much less successful after he lost the court packing plan. Without wishing to embarrass anyone, it is often the case that second-term office holders aren't as effective as they are in their first term.
Well, that we no doubt. And third termers are snake terms. Let me ask, when you look back and you say, think of the decisions, let's say three things. One, race, as it relates to Voting Rights Act, Civil Rights Act, affirmative action. You look at abortion. So you take those, you probably I would even add campaign finance. That's less of a social, more of a political. Do you think the court is an inhibitor or a promoter of social change? And are those decisions they basically haven't still resolved any of the issues?
That's right. Look, it's very clear in the short run, courts can inhibit social change. I think the best long-term example is Congress made two attempts in the early 20th century to outlaw child labor. In 1918, the court struck down the first attempt in a case called Hammer v. Dagenhart. 1923, court struck down the second attempt in a case called Bailey versus Drexel Furniture. Eventually, the court upheld the prohibition of child labor after Roosevelt's court packing plan. So the court allowed child labor to continue for a few decades. It lost in the end. With affirmative action, the court has not been the key player. The key player has been the executive, starting really with President Johnson, and then people on the ground. It's been universities, state governments, employers. The court has stepped in to draw some distinctions, draw some lines, but it really hasn't been the key player here. Now, as you know, there's this case challenging the use of race in admissions at Harvard.
Right, that's why I was going to go next,
And
so you're already there.
Yeah, this is based on Title VI, a section of the 1964 Civil Rights Act, which says institutions that receive federal funds cannot discriminate. Many supporters of affirmative action are concerned that this case, if it's appealed through the states, and it's in Massachusetts state courts, and to the Supreme Court, the court will use it to invalidate all affirmative action. Now, that could make a big difference.
Do you see the court, in the end of the day, moderating people's views when Roberts gets into position and realizes the court's legitimacy as much as the decisions are at stake here, therefore it changes the direction of a Roberts, a Rehnquist, a Warren, to use?
The jury is out with Chief Justice Roberts.
Yeah, right.
He has made what are seen as some moderate decisions, but they're pretty minor. They're more procedural. They're not substantive. The one substantive decision,
Healthcare.
Yeah, absolutely. And if you read his opinion, it's surprising. And we have some anecdotal evidence that he
overnight changed his view.
Yeah, and that he did it because he realized this was an election year. This was the signature piece of the incumbent president. For the court to invalidate it would put the court at the center of political debate.
When
That's
do you
not
think,
good for the court.
Do you look at public opinion about
all the time?
And where does the court stand today as an institution, giving Congress, the presidency, political parties today?
Traditionally, the court has done much better than the other branches. I think there's data that suggests people prefer colonoscopies and root canals to Congress. That's saying something. Faith in the court has been dropping. In part, that may be because faith in all government has been dropping. Americans don't know very much about what the court has done. So typically their view of the court reflects their view of the other branches.
So what decision do you think, or what process? A lot of people go back to certain Supreme Court nominees to say when the court got politicized. Do you buy that? Because I have a different theory.
Well, I want to hear yours. Yeah, I'd go back to John Marshall in 1800.
Well, I'm not going there.
Okay, where would you go?
I actually think the court set itself back in Bush versus Gore. I think there's where it decided that it was going to overreach its position and its place and became a political player. And you can almost, now a lot of people go back to Reagan's nominees in the Supreme Court, et cetera. But I would actually say the Bush versus Gore is a critical juncture in the Supreme Court's history of being seen as somewhat removed from politics or above politics or independent of politics, where it becomes a very partisan entity. And it's suffered since in the legitimacy of its opinions.
Right.
I think it's usually not looked at that moment, and I think that moment's a bigger play.
I actually think you're right about Bush v. Gore.
I got an A if I was in your class. I'm so happy. Go ahead.
Let's not get carried away here, Mr. Mayor.
Yeah, the mayor looks for one good answer to get an A. Okay, go ahead.
I would write, that's a very good point. And if we look at the court throughout history, though, it has
ebbed and flowed.
It has ebbed and flowed. And in part, we don't think of the Warren Court perhaps as political, but that's because there was a New Deal majority that certainly supported what it was doing. Again, I went back to the John Marshall Court. It's a very political court. History tends to treat it well because it was a supporter of the national government versus the states. The courts in the Civil War were very political. The post-Civil War court's view of
you think if Dred Scott had gone different, the Civil War would inevitably still happen or not?
Of course. Yeah. Of course.
So what are the decisions today that you're watching that you think are definitive as case studies for your view of the courts and social movements?
I have a lot of question marks here because we don't know which way the court's going to come down. Right now, I'm very concerned about the Shelby County case in which the court essentially...
You should probably describe it.
I'm going to, yeah.
Vitiated... We'd like to get beyond the audience of the 5 lawyers listening to today.
Yeah, who will, of course, criticize everything I'm saying. 1965 Voting Rights Act, which had a formula under which states with a history of voter discrimination could not change their voting procedures without preclearance from the Department of Justice. Well, the Roberts Court said, this formula is 40 years old, everything's changed, we have much less discrimination now, and struck it down. That has been huge. It's led to lots of voter ID laws that are aimed at suppressing the votes of racial minorities. It's led to lots of gerrymandering. Congress can change the law, but that's going to take Democratic majorities. That would be one issue. As I said, very concerned about what the court will do with affirmative action. Another issue is abortion. The court in 2016, in a case called Hellerstadt, the court did invalidate Texas laws that required abortion clinics to meet very strict standards of healthcare provision, which put almost all of the clinics out of business. Court struck that down. And you referred to Chief Justice Roberts' vote. There's a similar law out of Louisiana, and his vote was to affirm the injunction against it while a trial goes on. So it's really not a decision on the merits. There's one other point, though, that I want to bring up that I think is really important. In the end, public opinion is more important than the court. And that's because justices do not choose themselves. They are chosen by elected officials. And elected officials, to some extent, reflect public opinion. So let's take abortion. We know, we have very good data that strong majorities of Americans pretty much support access to safe and legal abortion for pregnant women. If the court were to strike down Roe v. Wade, I think that would unleash an enormous pro-choice movement.
Let me go at it a different way. You're doing social and cultural issues totally legit. Let's take the current political environment. You have at least a populist moment or an anger at concentration of wealth. You have 5 clear Republican appointees who favor that concentration. I'm writing this at 10,000 feet, broad strokes, okay? But when you look at Kavanaugh, you look at Alito, you look at Roberts, et cetera.
Don't forget Thomas.
Don't worry. Well, I try to all the time, but I can't seem to. So let me ask you a question. So you were talking on both choice and affirmative action or voting rights acts or civil rights in general take economic interests and concentration of economic interests versus consumers, individuals, labor, etc., they are out of step. So how does that, based on history and precedent that you see, how does that play out over, given, I think, another decision I would say is one of the worst the court's ever made, and President Obama pointed on dark money and the idea that corporations were citizens and had the same rights.
Right. Citizens
so how do you
United.
see that, Citizens United, how do you see that play out here? So get it more to the economic, not the social.
Right. I agree with your characterization
I'm
of
two
the
for
current,
two.
current
I'm 2 for
court.
2.
Well, you're a good student, right?
I'm working my way
You're
up.
Really
Thank
good.
God I'm not a lawyer. Okay, go ahead.
The question becomes, can a court sustain a set of positions in opposition to public opinion and political will? In the short run, yes. In the long run, no. And
So eventually it is a political institution.
it is exactly
So eventually it will bend to the political winds that are blowing.
because new appointees will join the court. And Congress has tools that can pressure the court. Don't want to get too much into the weeds, but in Article 3 of the Constitution, which creates the Supreme Court,
We haven't done this since 8th grade. Now I'm getting scared. Go ahead.
No.
Yeah, Article 3, go ahead.
It only has 9 sentences, Article 3. It says the court shall have appellate jurisdiction, that is, the jurisdiction to hear appeals from the lower federal courts, with such exceptions and under such regulations as the Congress shall make. This gives Congress the power to withdraw jurisdiction from the Supreme Court. And this is a power that Congress has repeatedly used throughout American history. We don't know the extent of it, right? We don't know how wide it is. And for example, the Republicans in the Bush years, in the president I call George II, twice tried to remove Supreme Court jurisdiction to hear appeals from detainees at Guantanamo Bay. Law was passed, president signed it, the court invalidated both of those. But it did it on split votes, and it may have been reflecting the fact that the American public was pretty torn on this.
Merrick Garland, is there a precedent where a Senate's ever denied the president the right to make a nominee and have a vote?
Oh, all the time.
So Merrick Garland was not out of step for Mitch McConnell.
What was out of step was the timing.
What does that mean?
In that there was plenty of time left in President Obama's term, something
So
like
that
that.
was all, in academic terms, BS.
Yeah.
Oh.
But look, the Constitution is very clear. Senate has to give its advice and consent. And so this was perfectly constitutional. It was morally outrageous, but it was not without precedent.
All right, 5 Supreme Court members in history that you think are either underappreciated or not known and should be recognized for their contribution. Or it could be 4, it could be 3. But
Boy, that's a hard one.
well, okay. I don't know if you've taken Professor Rosenberg's class. He's a pretty hard grader too. Okay, so
That's a hard
all right,
one.
where do you put Hugo Black? I mean, everybody writes about Brandeis, Frankfurt.
Right,
Where would you
right.
put Hugo Black?
I think he's overrated. I think he.
I'm not taking your class.
Yeah, he saw things as black and white. But here's the problem with this kind of analysis. So much of it is based on one's subjective agreement with the outcome. It's very hard to come up with a metric, a measurement of what makes a good justice, regardless of one's views of how that justice voted.
Wait, is there a justice you don't agree with, but you find their reasoning always tight, concise, and persuasive?
Chief
even?
Justice Roberts.
Really?
Yeah, I think he writes pretty good opinions that I seldom agree with.
Okay.
For example, his opinion in Obergefell, the same-sex marriage case, it's really very well argued. I think it's wrong, unlike Scalia, who goes ballistic, right? So Robert's really smart.
Are you surprised of the cult of personality around Ruth Bader Ginsburg?
Yes,
Why are you surprised?
because my work has suggested to me that courts seldom make much difference in furthering progressive changes. And to turn her into an idol, I think, distracts us from the real way in which change comes about, which is through political organizing.
So you think the focus on the court from that end is a distraction from the fact that real organizing happens on the streets, not in the courtroom?
Absolutely, and through elections.
Do you buy into the, I don't know if I would call it, I'll call it conventional wisdom, that the Eisenhower appointees were essential for the progress of civil rights?
No, because I don't think the court was essential to the progress of civil rights.
You don't, not at all?
The question is empirical. That is, can we measure
Well,
it?
then how did this image then, why do you think this is all written up in history? And you think some of the nominees that Eisenhower made that make some key decisions are not important in the civil rights movement? How did this then come about that people think that?
I'm actually writing a book on this.
Are you really?
Okay, I've written a couple hundred pages, and I actually had these couple hundred pages written almost 20 years ago. So I've got to get back to it now. There were things like children.
It's like a good bottle of wine. Just take your time. Before.
Let's hope.
Okay.
Here's the argument.
Yeah.
What my work has shown, and others agree, is that the key factor in leading to the 1964 Civil Rights Act and the 1965 Voting Rights Act, both of which made an enormous difference, was the civil rights movement. The key factor in the civil rights movement was World War II and the New Deal, not the court. And if this is right, then the court was reflecting the change rather than causing it. And in my book, I try and test the claim, look for evidence that the courts say influenced the civil rights movement. And can't find it.
Do you think a president today could have the same relationship that Johnson and Ford is?
I hope not, but President Trump has shredded all norms and expectations about how the president acts. I mean, you were in a position to know better than I.
I don't think. I think at least the two presidents I were, once they nominated, once they were seated, outside of maybe a state dinner, zero communication.
That sounds right. Now, of course, the Solicitor General's office, that's the office of the executive branch that represents the U.S. in the Supreme Court, they have a lot of contact with the justices.
Do you ever see us diffusing the politicization right now, or kind of the partisanship around the nomination process?
This would be really tough to do. It reflects, I think,
where we are now.
So if we ever reached a calmer era, it may well be that getting rid of the filibuster that used to require 60 votes in the Senate to confirm, if we brought that back, that might lower the partisan temperature because presidents would have to nominate more moderates. There's this really fascinating plan that came out of Duke Law School that we limit justices to 18-year non-renewable terms. Why 18? Because it's divisible by 9.
No, because in the Jewish faith, 18 reflects to life.
There you go.
Right. Once again. Yeah.
So, but think about this. So there'd be a nomination every 2 years. So every president would know she would have 2 nominees in her first term, maybe 2 more in the second. And the idea is this might lower the temperature because the next president is going to get nominations. So I think that's a clever idea, and now it has this added spiritual connotation.
I meant to ask you, where do you put Brandeis? Where do you put Frankfurter? And what do you think of the Eisenhower-Warren relationship?
Again, I'm not trying to dodge the question.
Don't worry about it. I'm not trying to pin you to the wall.
No, but it's just really hard to answer without.
They're kind of pop. I mean, they're in history. They're well known.
Right.
I don't think I can name 2 members that were with Brandeis. May say something about me.
Right. No, I mean, I'm a great fan of much of Brandeis's jurisprudence. He has this wonderful concurrence in a decision called Whitney versus California, where he makes an impassioned defense for free speech. And he has this sentence. He writes, let me see if I can get this right. Men feared witches and burned women. And he says the point of free speech is to help us overcome irrational prejudices. Men feared witches and burned women. He's great. Frankfurter, I think, much less of.
Why?
Because I think he claimed to believe in judicial restraint, and that was, I think, only to protect programs he agreed with, that he was not consistent. And I think he was from my point of view, a less notable justice.
Who are writers on the court that you read that you say these are the 2 to 3 people you got to stay current on?
You mean scholars of the court?
Colleagues of yours, people that you always, even when they're writing something in either the newspaper or popular journal?
Jeff Stone, for example, David Strauss. I always read Eric Posner. I don't always agree with him. Those would be some of the people I would point to. I mean, in the press, I'm a big fan of Adam Liptak's columns in the New York Times and his predecessor, Linda Greenhouse. Nina Totenberg on NPR is great. But they tend to do more news stuff.
Right. So a lot of what you write about is about the court, but then you talk about the importance really of the social political movements. What is it that you're studying there that's not either about a justice, a court, or an opinion?
What I'm interested, again, in trying to understand is how we as a society help the most vulnerable, those discriminated against, minorities, and dissidents. And I think that the court is very seldom the way to do that. And then when I've looked at the great changes that have come about, Social Security, anti-discrimination, health care, those have come through congressional action.
Let me ask you this question then. We talked about abortion, we talked about civil rights, we talked about economic rights. Do you think the court's opinion as it relates to the Second Amendment was rightfully interpreted, not your own political view? Do you think they interpreted the way, there's a lot of history written around the Second Amendment as it relates to militia, not individuals. That's kind of where it breaks down.
Exactly right.
So do you think the court's opinion as it relates to the Brady Bill and other gun legislation is on target?
No. I think the court was wrong in Heller, which found an individual right to own a gun, and then in McDonald versus our city of Chicago, the court held that that applied to the states. This is insane.
No, beyond what you and I obviously probably agree with as it relates to gun control, you think they're off base on their interpretation of the Second Amendment?
The question is, do we interpret it by looking at what the framers thought in 1791 when they adopted the Bill of Rights? And the problem with that is it's very hard to figure that out. And if there's any doubt, it seems to me you cannot then make guesses about it and then apply it to the 21st century. So no, I think they were wrong.
Okay. We're with Professor Rosenberg. Now we're going to do a rapid round to prove your Chicago roots. Are you ready? Cubs or Sox?
I grew up in the Bronx, sir.
So go ahead and pick.
Yankees.
No.
I once born a Yankee fan, always a Yankee fan.
Well, if you had a free moment and you had you paid your cable bill and you have WGN, do you watch the Cubs or Sox?
Neither. I turned it off. Okay. I streamed the Yankees.
That says a lot. We'll make sure you're not tenured. Thick or thin?
Too late.
Thick or thin pizza?
In Chicago, thick. In New Haven, Connecticut, thin.
Okay. Sears or Hancock Tower?
I prefer the Hancock, actually.
Okay. Chicago River or Chicago Lake?
The lake.
Okay. And 16-inch or 12-inch softball?
16-inch.
Really?
Yeah.
Okay. I'm surprised that's the one Chicago
it's great. I love it. I love it.
We'll give you a chance. We're here with Professor Rosenberg, The Hollow Hope, and it's a history of kind of the Supreme Court and social change. Thank you.
Thank you.
You've been listening to Chicago Stories with Mayor Emanuel. You can subscribe and leave a review on Apple Podcasts and tweet your guest ideas using #ShyStories. Thanks for listening.